We'll open up our webinar and start off with some housekeeping and introductions as some of you continue to sign on. Thank you for joining us this morning for our Hirsch Roberts Weinstein presentation, A Roadmap for Reopening a Massachusetts Workplace. This is our spring 2021 update. Thank you especially to those of you who were signed up to join us last week and are now coming together again this morning after we postponed last Tuesday morning in light of less than 24 hours earlier, Governor Baker's announcements around lifting COVID-19 restrictions and things we're going to talk about this morning. Some housekeeping. This webinar is being recorded, so your remaining on this webinar is your consent to the recording. You are all on mute, and your questions, as always, for our webinars are welcome. And the way that we found this works really well is through the chat box. And this morning we have Kathy Rubin and Dave Wilson, partners at HRW, joining us to assist in answering your questions in the chat. So please feel free to go ahead and answer those, put those questions in there, and we'll try to get them answered. In addition, let's go to the next slide, please. I'd like to just give an overview of what we'll be talking about today. We'll start off by discussing the current landscape, where we are now with lifting of restrictions, etc. We'll move into a discussion of the workplace safety standards and compliance issues. And then we'll turn to vaccination and vaccination questions and policies. From there, we'll address the interaction between COVID-19 and workplace policies. And to finish off, we'll talk about some remote workforce issues for you to think about. And we hope we'll have some additional time to potentially answer questions that weren't answered in the chat, or to perhaps highlight a couple that seem to be recurring themes. And with that, I'd like to just introduce briefly my colleagues, myself, Kathleen Burney, my colleague Mark Mackey, John Arnold, and Alicia Ward, who will be co-presenting with me this morning. Mark?
Thank you, Kathleen, and thank you everyone for joining us today and bearing with us through the postponement. If we can move to the next slide, please. So as Kathleen mentioned, last Monday, Governor Baker announced an accelerated reopening schedule in light of a recent CDC advisory update. And we wanted to make sure we brought you the most up-to-date information available, hence the postponement. So what motivated the accelerated reopening? Well, I think we can credit the governor's announcement to the CDC's updated advisory concerning vaccinated individuals and face coverings, as well as the progress that Massachusetts has made with respect to vaccinations. And if we can go to the next slide. So looking at that vaccination progress, as I'm sure everyone's aware at this point, there are 3 vaccines that have received emergency use authorization. And those are Moderna, Pfizer, and Johnson & Johnson. The Moderna and Pfizer vaccines require the administration of 2 doses, and the Johnson & Johnson vaccine requires a single dose for full vaccination. Pfizer is currently in the process of seeking full FDA approval as opposed to the emergency use authorization for its vaccine. And it was also recently granted emergency use authorization for adolescents aged 12 through 15. And as some of you may be aware, there are already clinics in Massachusetts administering vaccines to that population. And also, as you may remember, use of the Johnson & Johnson vaccine was temporarily suspended. However, that suspension was lifted and use of the vaccine resumed on April 23rd. So why am I talking about this? Let's go to the back slide. So, I'm sorry, last slide, please. Why am I talking about this? What is all the development of various vaccines and expanded availability led to? Well, in Massachusetts, as of yesterday, the state reported that 3,454,126 individuals in the Commonwealth are fully vaccinated, and an additional 4,086,923 have received at least 1 dose of the Moderna or Pfizer vaccine. Now, these are huge numbers. We're approaching 50% of Massachusetts residents being fully vaccinated, and COVID rates are way down. And the success that Massachusetts has had with its vaccination program is undoubtedly one of the reasons the reopening has been accelerated. But also on May 16th, as mentioned, the CDC announced that it was updating its advisory to provide that fully vaccinated people can resume activities that they did prior to the pandemic without wearing a face covering and without social distancing, except where otherwise prohibited by federal, state, or local law or regulations. And this is where Governor Baker's announcement concerning the reopening comes into play. But before I get into the details of the announcement, we have a poll question for the audience. We can go to the next slide now. So we want to know from you, what percentage of employees do you anticipate to be fully vaccinated at this point? And you're going to get a pop-up screen with the poll question, and it's 0 to 25%, 25 to 50%, 50 to 75%, or 75 to 100%. Please log your answers, and we'll give you a minute to do that. Okay, if we can. All right, let's see. All right, so about 3% of the audience thinks 0 to 25%. About 25% of the audience thinks 25 to 50%. The largest portion, 41% of the audience thinks 50 to 75%. And 30% of the audience thinks 75 to 100%. So I'd say that's pretty much, on point with what we just talked about with Massachusetts vaccine rates. The 50 to 75% being the large majority. Great to see that, about 30% of the audience feels that 75 to 100% of their population or of their employees are vaccinated. So, we're progressing, and that's, great news. It's a great indication of where we're headed. If we could head to the next slide. And speaking of where we're headed, on Monday, May 17th, Governor Baker made the announcement that the Massachusetts reopening plan was being moved up. According to the announcement, as of May 29th, so this upcoming Saturday, with certain exceptions related to face coverings, which I'll discuss in a moment, all industry restrictions will be lifted and capacity will increase to 100% for all industries, and the limits on public and private gatherings will be rescinded. Then on June 15th, 2021, the state of emergency that first went into effect all the way back in March 2020 will be lifted. And I'm going to talk about some of the implications of the state of emergency being lifted in just a moment. But first, one note about Governor Baker's announcement is that, though the state mandates concerning industry-specific restrictions and requirements will be lifted, businesses are encouraged to continue to follow CDC guidance for cleaning and hygiene protocols. And this was right there in the announcement. The state's still encouraging businesses to follow those CDC guidance for the cleaning and hygiene protocols. Another point to be made here, and that John will be speaking about in greater depth, is that even though the mandates will be lifted, employers and companies remain in control on how to operate their businesses. It will be a company-specific decision on the extent to which the company may decide to continue to keep certain COVID protocols in place and for how long. Just because the mandates are being lifted doesn't mean it suddenly becomes illegal to require patrons or employees to wear face coverings before entering your business under the same terms as when the mandates were in place. It will be up to the company to decide what is best for its workers and its customers, and also keep in mind how federal laws such as OSHA may impact the decision-making process. And, that's another point that John's going to be speaking about later in the presentation, that OSHA point. If we could go to the next slide. So with respect to face coverings, the face covering order that was in place in Massachusetts will be rescinded as of May 29th and replaced with a face covering advisory that will be consistent with the CDC's advisory. As mentioned, the CDC advisory provides that fully vaccinated individuals no longer need to wear face coverings in any setting and no longer need to socially distance. Individuals who are not fully vaccinated continue to be advised to continue to wear the face coverings and socially distance, but as of May 29th, will no longer be required to do so in Massachusetts. But, just like the industry specific standards, just because the face covering requirement is no longer mandated by the state does not mean that you as an employer cannot require employees or customers to wear face coverings when coming into your business. Also, face coverings will continue to be required in certain settings, including public or private transportation, healthcare facilities and provider offices, in congregate care settings such as assisted living facilities and group homes, in healthcare and rehabilitative day services and programs such as adult day health programs, and in certain community and home-based care settings. Additionally, face coverings continue to be required inside for K through 12 and early education schools and other childcare programs licensed or authorized by the Department of Early Education and Care or the Department of Elementary and Secondary Education. However, face coverings will not be required for student outdoor activities like recess. So the state also expects to issue updated guidance concerning summer programs, which are obviously on the horizon by May 29th. So, if you operate a summer program or you have a kid that's looking to get into a summer program, stay tuned for that updated guidance. We go to the next slide, please. So as mentioned, the state of emergency will be lifted on June 15th. And as a result, several pieces of legislation will expire either as of or at some point after the lifting of the state of emergency. One area where this will impact is unemployment insurance. During the pandemic, the legislature passed a law which in part waived the 1 week waiting period for unemployment benefits. And this waiver will expire in 90 days after the state of emergency is lifted. Now, this change will likely not have, much, if any, of an impact on those already receiving unemployment benefits. But what will likely impact those currently on unemployment is this second point on the slide that the Baker administration recently announced, which is that work search requirements to receive unemployment will be reinstated, which will actually happen on June 13th, as that's the beginning of the unemployment week for, that corresponds with the June 15th state of emergency being lifted. So, just a refresher, during the pandemic, the DUA waived the requirement that applicants must attest to making at least 3 work search activities per week and provide proof of such activities in order to receive unemployment benefits. This requirement will be reinstated with the goal of getting more individuals back into the workforce as industries begin to reopen. Another point is for our restaurant clients, the legislation allowing for to-go cocktails and placing caps on the delivery fees charged by third-party services such as Grubhub or DoorDash is set to expire with the state of emergency. I understand that Senator Diana DiZoglio out of the Merrimack Valley area and maybe some other legislators have introduced some legislation in an effort to allow for a continuation of the to-go cocktails and caps on the delivery fees beyond the state of emergency. But I do not believe that such legislation has passed to date. And then another area to be aware of is that the legislation allowing for virtual notarization is set to expire 3 business days after the state of emergency is lifted. So during the pandemic, if you needed something notarized, you could just hop on Zoom with a notary and it would work out that way. But once this legislation sunsets, you'll have to go about the pre-pandemic notary protocols, the face-to-face notary interactions. It's just something to be aware of in case you need to get something notarized for your business in the near future. And also, there are additional orders and legislation that will expire in connection with the state of emergency being lifted. WBUR put together a list of some of the other pandemic-related measures that will expire, and I'll drop that article in the chat in just a moment, just in case any of those other measures impact you or your business. But with that, I'm going to turn it over to John, who will talk a little bit about the best practices and workplace standards in light of Governor Baker's recent announcement.
Thanks very much, Mark, and good morning, everyone. So despite the lifting of restrictions, the end of the mask mandate in most situations, and surging optimism across the Commonwealth, we are not out of the water yet. As Mark mentioned, many people have not yet had their first vaccine shot, and many others will never be vaccinated, whether by choice or not. This means that there are important considerations for your business in implementing or making changes to your return to work plan. Ultimately, only you can decide whether it makes business sense to reopen or what workplace safety standards and restrictions you wish to keep in place or to lift. Let's talk about some of those choices now. Go to the next slide, please. So right now, there are a lot of questions in the air with the Commonwealth following the CDC's lead on lifting restrictions and advising that vaccinated individuals do not have to mask or socially distance while indoors. So let's start with the basic OSHA workplace requirements. The Federal Occupational Safety and Health Act, OSHA, which applies to Massachusetts employers, contains what's known as the General Duty Clause, which requires employers to provide a place of employment free from recognized hazards. And that clause is what gives OSHA guidance teeth. So employers can be cited for a violation of the General Duty Clause if a recognized serious hazard exists in the workplace and the employer does not take reasonable steps to prevent or abate the hazard. On the one hand, OSHA has begun ramping up enforcement actions against COVID-19 workplace hazards. For example, in March 2021, OSHA launched a one-year national emphasis program, which will increase COVID-19 inspections in industries that put the largest number of workers at serious risk of contracting the coronavirus, such as hospitals, assisted living centers, and others. In addition, OSHA's national emphasis program guidelines also note that in an anti-retaliation effort, OSHA will be targeting establishments where employees have complained about unsafe or unhealthy environments. This is very different from how OSHA operated in 2020, where the majority of COVID workplace complaints were handled by employers who self-investigated, reported findings and safety measures to OSHA, and cases were closed out without formal OSHA inspections. As the owner of a business in Lynn, Massachusetts found out this last March, OSHA is serious about these efforts. A tax preparation service in Lynn was slapped with a $136,000 fine after an OSHA investigation led to a finding of COVID-related negligence just days after the National Emphasis Program was launched. Specifically, the business was cited by OSHA for prohibiting employees and customers from wearing face coverings in the workplace and requiring employees to work within 6 feet of each other and customers for multiple hours while not wearing face coverings, and a few other issues, including lack of adequate ventilation. So while this violation was issued prior to the new CDC guidance on vaccinated individuals, and certainly this employer's conduct was egregious, the key takeaway is that OSHA has made clear that it is back on the offensive enforcing its guidelines. We can go to the next slide, please. So going all the way back to January 29th, 2021, which feels like a whirl ago now, after many months of anticipation by employers and counsel alike, OSHA published a 12-page guidance document titled Protecting Workers, Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. In the background of that, President Biden issued an executive order shortly after he was sworn into office, directing OSHA to review its guidance for consistency with scientific information known about COVID-19 and to consider promulgating an emergency temporary standard to address circumstances caused by the pandemic. A few months later, OSHA has still not issued that standard. Then, on May 13th, as Mark mentioned, the CDC released its current guidance on vaccinated individuals. Go to the next slide, please. A few days later, on May 18th, OSHA added a banner that you can see before you to its website, which simply states, OSHA is reviewing the recent CDC guidance and will update our materials on this website accordingly. Until those updates are complete, please refer to the CDC guidance for information on measures appropriate to protect fully vaccinated workers. So OSHA has not made entirely clear how employers should apply the CDC guidance in workplaces. The banner also appears to conflict with OSHA's prior directions to employers to treat vaccinated and unvaccinated employees equally for purposes of evaluating and responding to potential COVID-19 hazards. OSHA is also unclear as to what guidance it will use for enforcement purposes. Next slide, please. So the existing January 2021 OSHA guidance suggests that employers should adopt a prevention program to actively protect employees against COVID-19 transmission. However, the question now is what parts of a prevention program employers should institute or keep in place, and which no longer apply given the new CDC guidance and Massachusetts lifting COVID restrictions. For example, in the January 2021 guidance, OSHA advised that employers should treat workers who are vaccinated the same as those who are unvaccinated. OSHA advised that vaccinated employees should still wear a face covering and remain socially distant due to the uncertainty then of whether the COVID-19 vaccines would prevent transmission of the virus from person to person. That belief has, of course, changed. Since the banner on OSHA's website does recommend following the new CDC guidance with regard to protecting fully vaccinated individuals, it follows that employers are likely now permitted to treat vaccinated and unvaccinated workers differently, but OSHA has yet to clarify. As number 3 on the slide states, OSHA's guidance also advised employers to identify a combination of measures to limit the spread of COVID-19. With the general duty clause in mind, employers may wish to either implement or maintain some of these measures, such as eliminating the hazard by separating and sending home infected or potentially infected people from the workplace, installing barriers where physical distancing cannot be maintained, improving ventilation, using applicable PPE to protect workers from exposure, providing the supplies necessary for good hygiene practices, and continuing to perform routine cleaning and disinfection. Next slide, please. So the OSHA January 2021 guidance also included what you see on this slide. Importantly, we expect that no matter when or if a COVID work standard is issued by OSHA, employers will still need to record and report COVID-19 infections and deaths. Employers should also continue to take an employee safety-related complaint seriously and be careful not to retaliate against that employee. So a safety complaint these days might manifest as something like an employee asking why the workforce is not required to wear masks anymore, why you are or are not tracking vaccination status, or if the employee expresses their discomfort about your new safety protocols. Again, what's important is that you investigate their complaint, document the process, and take great care to not retaliate against that employee. Likewise, under the realm of the general duty clause, you'll want some protocol in place to ensure you don't allow sick people into your workplace, be it health screenings or other measures. So the rest of these practices will likely be familiar to most of you as they track previous CDC guidance. Next slide, please. So switching gears now, let's focus on the Massachusetts safety standards, which are represented in these familiar 4 pillars of workplace safety that many of you have seen over the past year. So face coverings and social distancing, staffing and operations, hygiene protocols, and cleaning and disinfecting protocols. As a starting point, I want to reiterate what Mark mentioned earlier. No matter what, you have the option to maintain each and every one of these safety standards, even with the Commonwealth lifting them as requirements. Next slide. So as you can see on this slide, on May 29th, when the governor's order regarding face coverings is lifted, the current advisory from the Massachusetts Executive Office of Health and Human Services lists face coverings and social distancing requirements for those who are vaccinated. If you're fully vaccinated, you can essentially go back to living life like it's 2019. If you're not fully vaccinated, the face covering advisory states that it is important that you continue to wear a face covering or mask and that you continue 6-foot social distancing, continue to abide by standard hygiene protocols like washing your hands often, and get tested if you've been exposed or are experiencing COVID symptoms. But just because masks are no longer mandated for vaccinated individuals does not mean that you, as business, cannot require employees and patrons to continue wearing face coverings. That decision, however, will need to be made on a business-by-business basis based on your particular needs. So the mask and other restrictions question for employers boils down to the following options. 1, continue to require masks and social distancing of everyone for now. Evaluate community infection rates in your workplace before making any further changes. 2, lift all restrictions, but require the unvaccinated to continue to wear masks with the Massachusetts advisory and CDC guidance for vaccinated individuals for support of that position. Or 3, lift all restrictions and rely on the honor system that the unvaccinated will continue to wear masks on their own and socially distance per the Massachusetts mask advisory and CDC guidance. Next slide. So back in the halcyon days of pre-COVID work, it used to be fairly standard, if not expected, that someone who is coughing, feeling unwell, looking blue, or otherwise has the symptoms of a minor cold would still come in and work through it. Not anymore. We're still firmly in the COVID era, and employees exhibiting COVID-19 symptoms should be firmly instructed to stay home. As of May 29th, like with all industry restrictions, the Commonwealth will no longer require you to implement screening measures at each shift to help protect your workforce. So the question for you and your business to consider is whether you will continue to implement daily temperature checks or daily health screenings or questionnaires or a combination of all of these. If you continue the screenings, will you inquire about vaccination status? Kathleen will talk about this a little more next. Another point for you to consider is whether fully vaccinated individuals or those that have recovered from COVID in the preceding 3 months will be exempted from your screening protocols, given the CDC guidance that those individuals do not have to quarantine or isolate after exposure to COVID-19, so long as they are not experiencing symptoms. Go to the next slide, please. So per the Massachusetts safety standards, you may be aware of the requirement that employers shall notify the local board of health of cases of COVID-19 in the workplace. While we await further guidance from Massachusetts Department of Public Health on that point, it remains the current standard. So as an employer, you still want to plan ahead for the day that an employee notifies you that they are positive for COVID-19 and keep at least some of the measures you have in place for what to do next. For example, you may want to conduct workplace contact tracing and ask the positive employee who they came into close contact with and whoever else they might have seen. However, you must maintain employees' confidentiality and you must not disclose their name to other employees. Even when it's obvious who you're talking about and everyone knows who you're talking about, you must continue to take the appropriate measures to maintain that worker's privacy. On that note, the safety standards state that employers must maintain a log of workers and customers support contact tracing, including name, date, time, contact information if needed. You may wish, at least in the short term, as you bring employees back and or lift restrictions, to keep these contact logs in place as an effective way to retrace who in your workforce may have come into close contact with a positive employee. Another measure you may wish to retain to some degree is testing. Testing may not be needed most of the time for vaccinated individuals. However, it may be an important tool for unvaccinated individuals that exhibit COVID-19 symptoms. It could also be part of a plan to reasonably accommodate employees who cannot get vaccinated for legally protected reasons like a medical condition, pregnancy, or religious objections. Next slide, please. So under the prior CDC guidance, employers generally needed to have a return to work plan for employees who were exposed to or tested positive for COVID-19. While it will no longer be technically required as of May 29th, it may prove helpful to follow the prior guidelines. So I'm not going to go through each of these scenarios before you, but as you can see, there are several different variations on how long an employee must remain outside of the workplace per the CDC. Of note, however, is that the close contact provisions may not be relevant to vaccinated employees or employees that had and recovered from COVID within the prior 3 months that had a close contact to a COVID positive person. Again, though, as an employer, you have the control to decide what works best for your workforce. Next slide, please. So as you may remember, this was the poster you were required to hang to attest to your compliance with the then effective guidance. You're no longer required to keep it up, but you may wish to do so. The CDC still encourages all businesses to continue to implement cleaning, disinfecting, and hygiene protocols. While these protocols were originally assembled to combat the spread of COVID, they also help protect businesses against outbreaks of flu and common cold, which can otherwise have negative impacts on business operations. Next slide. So although this was not a requirement from the CDC or the Massachusetts safety standards, some employers have required employees to review and acknowledge that they have received and understand the company's COVID reopening plan and policies, just as many employers ask their employees to acknowledge handbooks and other policies of that sort. So as you begin to consider returning to the workplace, you might consider preparing a return to work plan so that employees will understand what things will look like when they get back, what changes will occur, if any, and what expectations of them will be moving forwards. So here's a list of the general topics your acknowledgement forms may have covered in the past or might cover in the future. So now, with further lifting of the COVID restrictions, you will again make decisions about which of these areas apply. You may require all employees to conduct self-checks, to socially distance, to stay out of work if they're sick, and to abide by company travel requirements, which Mark will talk about later. You may also have carve-outs for unvaccinated individuals and require them to acknowledge that they solely must still wear face coverings and or socially distance while in your workplace. If that is the policy you elect to adopt, every business is different and reopening plans and corresponding acknowledgements of the same will need to be tailored accordingly. So with that, I'd like to transfer you over to my colleague, Kathleen, who will cover vaccination policies and more.
Thank you, John. And good to be back with you this morning. And I know that vaccinations and vaccination policies and questions have been top of mind for employers throughout this pandemic. And now, with the CDC's recent guidance for vaccinated individuals and the lifting of the Massachusetts COVID restrictions on May 29th, this has raised even more questions, I recognize, for those of you on the call this morning. Next slide, please. So we thought that we would have a little quiz question for you. True or false? An employer in Massachusetts may legally mandate its employees to be vaccinated. So you can go ahead and click in question number 2 that popped up, true or false. We'll just give a minute for your data to tally here. And okay, here we go. So, yep, you know, none of these answers, none of these questions are easy this morning. And this shows that 63% of you got it right. This is true. But this is not clear to everyone, which is why we're here this morning to talk about it. The answer is certainly true in Massachusetts, and we'll talk some more about that and why that is the case. Next slide, please. So let's start with Massachusetts, the state. Massachusetts courts have already addressed that vaccinations may be mandatory, and much of the case law is around flu vaccinations. And the takeaway is that they're generally lawful so long as reasonable accommodations are provided to those employees who require them, which we'll talk more in detail about. Now, the reason that I want to emphasize that I'm discussing Massachusetts right now is because if you're an employer with locations in other states, you'll want to check those states as well as those local laws. There is a lot of activity out there with certain states having pending legislation to ban mandates. So definitely take a look at that for your employees who are working there. Next slide, please. So with respect to federal law, the Equal Employment Opportunity Commission, or the EEOC, which has the job of enforcing workplace protection laws, they issued guidance. They've been issuing guidance throughout the pandemic, but on December 16th of 20, the EEOC issued guidance around mandating vaccinations, and employers and council across the country were waiting for this to be issued. And essentially, what they provide in their guidance is that employers may mandate the vaccine without running afoul of the anti-discrimination laws that they have jurisdiction over, but there are important caveats to those mandates. That is, an employer must take into account the requests for reasonable accommodations, absent undue hardships for certain employees who may need them. Next slide, please. So these are those laws that the EEOC has jurisdiction over. The Americans with Disabilities Act, which protects employees from discrimination based on a disability, and which will require employers to provide reasonable accommodations to those employees absent undue hardship, and also provides rules around when employers can require or request medical examinations and medical related inquiries. Title VII prohibits discrimination based on protected class status, such as race, color, national origin, pertinent to the vaccinations on the basis of religion and sex, which includes pregnancy. And finally, there is GINA, which is a law that protects employees from the employers making decisions based on their genetic information. Next slide, please. In its December 16th, 20 guidance, the EEOC has made it clear that if an employer is to mandate the COVID-19 vaccination, they must provide vaccination exemptions for those with legally protected reasons for needing those exemptions, such as medical reasons, religious reasons, and for reasons associated with pregnancy. Next slide, please. So let's turn to the ADA, the American with Disabilities Act, and considerations under the ADA. In normal pre-COVID times, many of you know that the EEOC, in its enforcement of the ADA, limits an employer's ability to make disability-related inquiries or to require medical examinations of its employees and its candidates. For example, many of you know that before you offer an employee a job, medical inquiries are generally not permitted, but that once you make that employee an offer, you may ask disability-related questions or require a medical exam, so long as that inquiry is job-related and consistent with business necessity. Direct threat comes into play in the pandemic. The EEOC recognized early in 2020 that COVID-19 had been deemed a direct threat by the World Health Organization. And so in line with that, they relaxed certain of those ADA rules around what employers are permitted to do or not do in the workplace. And many of you have been doing this over the course of the last year or year and change, asking employees to take their temperatures, administering health screenings, asking or requiring COVID-19 tests before entry or re-entry into the workplace, and excluding workers from the workplace when they are positive or exposed to COVID. Turning to the vaccine mandate, the EEOC guidance states that an employer who is going to mandate that the vaccine must provide those reasonable accommodations absent undue hardship for those employees who have medical conditions or disabilities that prevent them from getting the COVID-19 vaccination. The way that an employer will determine how they may reasonably accommodate an employee, say for an example, a pregnant employee, is to engage in the interactive process with that employee. Next slide, please. So this slide gives you the EEOC's guidance on what you as an employer may ask an employee with respect to their informing you that they may have a disability or a medical condition that precludes them in this discussion from getting the COVID-19 vaccination. Now, as always, just as you've always engaged in the interactive process, this is a flexible dialogue. It's between you and the employee, and the goal is to determine what the accommodation is that will allow that employee to complete the essential functions of their job. Remember, as always, the employee may have an idea of what they need or want for their request for accommodation, and sometimes that will be exactly what you as the employer can provide or will provide. And in other instances, you may counter with other potential accommodations. An employee, for example, probably the biggest way this will come up, certainly in the mandate realm, is that an employee wishes to work from home. And through the interactive dialogue, you may either grant them their request to work from home for whatever reason they may have. For example, perhaps they're someone who's extremely vulnerable. Even if they're vaccinated, they may have just finished a course of radiation or chemotherapy. And even that slim margin of exposure to the virus would be too much for them pursuant to their medical documentation to permit them to safely work in the workplace. And that's part of what your interactive process with employees will be. As always, you'll ask them for medical documentation to support their request for accommodation. In other instances, you may strike a reasonable accommodation where an employee who does not get the vaccine returns to the workplace, but has certain safety precautions in place, perhaps a HEPA filter. Perhaps they're relocated to a different part of the workplace where they're not as exposed to others. Perhaps there's a flexing of their work shifts. That is something that you'll work through one employee at a time, considering their job, your industry, and that particular employee's requests. Next slide, please. Religious accommodations. If you intend to mandate, you will also need to engage in this interactive dialogue with employees who seek a religious exemption. Now, employees may be entitled to religious accommodations for their sincerely held religious beliefs, unless that accommodation would present an undue hardship for an employer. Keep in mind that under Title VII, the EEOC takes a broad view of religion. And the EEOC in Massachusetts courts recognize not only traditional organized religions that you may have heard of, but religious beliefs that are new, that are uncommon, or that are not part of any organized church or religion. In granting religious or medical accommodations, you will want to, for best practice, document all the steps in the process. And you'll want to also make sure that you document the understanding with the employee so that you make sure you're both on the same page about what the agreement that you strike together is. So next slide, please. So we thought it would be interesting to poll you on whether you plan on implementing a policy in your workplace mandating the vaccine. And for this question, we ask you to choose from 3 choices. Yes, you plan to mandate. No, you do not plan to mandate the vaccination or the vaccine, or you are unsure. So we'll let the data gather here for one more moment. And it looks, this is really interesting. This is different than when we asked this question back in January when we had our HRW webinar on vaccination. I think that the lifting of the restrictions is certainly informing thinking right now. Only 8% of you, this is not a surprise, only 8% of you are thinking about or planning to mandate. 50% of you are a no, but 42% are unsure. And that makes sense to me, given the questions that you're facing now about the lifting of restrictions. Next slide, please. So now we're going to move into some questions that we've been getting from a lot of clients throughout the pandemic, and particularly recently. And the first question is, what documents should employers mandating the vaccine consider? Next slide. And if you are in that 8% that answered this poll that you intend to mandate or that you already are mandating, I do recommend that you strongly consider implementing a vaccination policy. Given the fact that you're going to mandate the vaccine, it's really important that employees understand the expectation, that you have that expectation documented, and that candidates also understand that expectation in your job descriptions and in your offer letters. Things to think about to be included in your vaccination policy are how, whether employees will be given time off to get the vaccine and or to recover from the vaccine. Mark will talk a little bit more about the extended voluntary FFCRA, which would permit you to pay employees and get a tax credit for doing so for those steps to get the vaccine. In addition, you will probably want to have some sort of hard deadline around timing for when an employee is required to get the vaccination. Certainly a mandated policy must mention the request for accommodations process. And as you think through that and as you implement that, you'll potentially want to have forms so that it's easy for employees who need to make those requests to do so. Next slide, please. Here's another quiz question for you to answer, and you'll answer true or false. A Massachusetts employer may lawfully ask employees whether they have been vaccinated and for proof of vaccination. So please answer in the question 4 box whether you think this is true or whether it's false. Can you ask employees whether they've been vaccinated, and can you ask them for proof of vaccination on those vaccination cards we've all been seeing pop up? And yes, most of you got this one right. You can ask employees whether they have been vaccinated. This is true. And you also may ask for proof of vaccination. Next slide, please. So we said that you can ask whether an employee has been vaccinated. And the reason we say that is because of the EEOC's guidance that came out and said that the COVID-19 vaccination is not a medical exam. So that means that you're asking an employee whether they have been vaccinated, and you can move to the next slide, please, is not a disability-related inquiry. If it's not a medical inquiry if it's not a medically related incident to get the vaccine, then asking about it is not a medically related inquiry. So one of the things you'll want to think about, though, and this will apply beyond those of you intending to mandate, if you're an employer thinking about tracking vaccination status of your employees, this will be important for you to think about. And that is, when you ask your employees whether they have been vaccinated, and you have no intention of mandating and getting into the interactive process with employees seeking exemptions, you'll want to stop short of asking them why they haven't been vaccinated, if that's the case, because that would likely result in them giving you that kind of information. The other thing is that if you do ask your employees about their vaccination status, you'll want to make it clear, just answer the questions yes or no, or just provide us proof of your vaccination or the vaccination card. Please do not provide us with any further medical information. Next slide, please. This is the million-dollar question, and I know that this is one that many of you have been thinking about since last Monday's announcement. Can we permit our vaccinated employees to go maskless and require our unvaccinated employees to continue to wear masks in the workplace? As John mentioned earlier, employers have a few options here. One option will be to continue to require masks of everyone for now. Some employers are taking the position that part of their role is to protect the unvaccinated amongst them in the workforce. They're thinking they might evaluate whether there are any community infection rate spikes, whether there are any workplace infection rate spikes before dropping the mask mandates in their workplace. The second option is to lift all restrictions, but to require your unvaccinated employees to continue to wear masks as the Massachusetts Mask Advisory and the CDC guidance recommend. And part 2 of that would be for you to collect information about your employees' vaccination status and to track their status. Option 3 would be, like number 2, to lift all the restrictions, but rely on the honor system, that the unvaccinated amongst your workforce will wear masks per the Massachusetts and the CDC's guidance. I know that you're probably looking for a black and white answer here, but it really comes down to what's the right decision for your workplace, and that will be based in part on your industry, Whether you're in healthcare, it might be a completely different paradigm if you are a high-tech company. Also, whether your population, be it employees or customers, clients, are highly vulnerable to the virus, that might influence your decision around lifting restrictions or maintaining restrictions. Whether your employees have public-facing roles may make a big difference. And certainly, the vaccination status of your workforce, what part of the country you're in, if you're listening right now outside of Massachusetts, given the political divide over some of these issues, may also play a part in that decision-making process. Next slide, please. So speaking of tracking, what should employers be thinking about with respect to tracking of employees' vaccination status? So this is front and center right now. Here are some things that we do know. We know that the federal government of the United States has already announced that it has no intentions of mandating the vaccine or to create a federal vaccine passport that would, in essence, track employees, which people, not necessarily just employees, but would track whether an individual has gotten the full vaccination dose and whether they've been tested, for example, for COVID. They have no plans on doing this. And some businesses have already, you've been reading the news like the rest of us, some businesses with public-facing customers like Trader Joe's have announced that they're going to rely on the honor system, and they're going to trust that their unvaccinated customers will wear the masks indoors, and they're going to let everyone in without any checking. With this question in mind, some employers have taken initial steps like issuing surveys. Surveys are a really good way for you to gauge your workforce right now. Some employers might find that they're lucky, and if they're a small workplace, then they've got 100% compliance with vaccinations. I don't know how likely that is, but especially the larger your organization is, but it is really good data for you to have to figure out what your starting point is, what you might be up against with resistance from employees, and to just think through your strategy. Now, no matter what decision you make, you're probably going to get pushback from certain employees. Some employees will feel that if you lift the restrictions, that you're not creating or maintaining a safe work environment. Other employees, if you lift restrictions and, for example, track vaccination status, will feel like you're out of touch with the science, or you're overly intrusive in terms of probing their confidential, private, personal information. Interestingly, I'm doing some of my research, I noticed that New York State has a voluntary tracking app. It's called the Excelsior Pass, and that's a digital pass that will allow individuals to provide digital proof of their vaccination status and COVID testing results if necessary, and that they can provide to restaurants and sports arenas and other places in the New York State. I have not heard anything about that happening in Massachusetts, but certainly just like we saw a lot of those apps pop up for health questionnaire and tracking throughout COVID, we're likely going to start to see more of these digital passports. And certainly you've probably heard about the EU's move towards a international data digital passport. One of the things you'll want to look at for your industry is, what are your competitors doing? Are your competitors tracking their employees' vaccination status? Will there be pushback from your employees for doing so? Could it impact retention? Those questions really go to pretty much any of the decisions you're making right now. But tracking is a good way to gather data, but won't be without resistance if you do it. Next question, please. Next slide. So what does an employer do when an employee who is vaccinated? Sorry, wrong slide. My company intends to mandate vaccines. Can I ban or terminate employees who do not get the vaccine from the workplace? And the answer to that is that it depends on the reasons why your employee is not getting the vaccine. I've talked about those who have legally protected reasons for not getting vaccinated. Those employees will be you need to engage in the interactive dialogue with them. However, if an employee has a vaccine hesitancy or they're an anti-vaxxer, you are not necessarily required to retain them if they do not follow your policy. And that's what's hard about a mandate. And that's why only 8% of you so far have said yes to that, because the difficult decisions you might have to make about terminating somebody for lack of compliance with your policy. Next question, please. My CEO would like to ban discussion about employee vaccination status and masks in the workplace. Can we do this? The answer is you should not do this for a couple of reasons. One of them is that even in a non-union workforce under the National Labor Relations Act, employees have the right to discuss workplace conditions, and you're prohibiting them from doing so could violate the NLRA. Furthermore, John mentioned earlier OSHA and the anti-retaliation provisions and enforcement that seems to be stepping up a bit earlier this year. If your employee is asking about masks or asking about vaccination status and you clamp down that discussion, they might claim that they were raising a safety concern or making a safety violation complaint, and that you stop them from making that inquiry or complaint to you. So I understand that this is one we'd like to, for some of us, do, but perhaps another way to address this would be by encouraging respect and communication in your workplace, and a recognition that we may all have different views on these topics. Next slide. What does an employer do when an employee who is vaccinated requests to continue working from home? Now, I think the answer to this is the same that we've already talked about. This will come down to whether there's a legally protected reason for them working from home or not. And if they're vaccinated, I mentioned earlier, there could even be somebody who is vaccinated but has a vulnerable medical condition that may require them to continue to work from home. You'll check whether the reason is legally protected or not. You'll go through the interactive process if it is. If it is not, you have some discretion about what to do next, and you'll probably want to make those clear in policy so your employees can understand the expectations. Next slide. Our company does not wish to mandate the vaccine, but we would like to know how we may encourage it. Next slide, please. So just last week, the Commonwealth came out with an employer's vaccination program. And I believe if you have 10 or more employees who are interested in your workplace, you can actually sign them up for the vaccination shots at certain sites. If you have 35 or more employees, you may request vaccinations on site at your workplace. Other ways that employers have been working to encourage but not mandate the vaccine are through leadership, publicizing their and celebrating their vaccinations. And sometimes employers are providing that time off that Mark will talk a little bit more about to get and to recover from the vaccine. Another way is to offer low cost swag to your employees. You probably don't want to get into high dollar amounts here because it's unclear whether that might violate EEOC guidance around incentives. But I've heard some creative solutions or ideas that employers have been coming up with, even using the mask mandate as a carrot for vaccination. For example, saying that once your workplace reaches X% of vaccinated status, that you'll have some kind of celebration, an outdoor celebration, or you'll do something together to celebrate that. And that when you get to say 80–90% vaccination, that at that point, your workplace will lift the mask mandate. On that employer vaccination program website, there are materials, educational materials that you can download and you can share with your workforce as another way of encouraging the vaccinations. Next slide. And with that, I turn it over to Mark.
Thanks, Kathleen. Now I'm going to speak a little bit about some of the ways COVID may interact with workplace policies. we go to the next slide, please. So the main area of interaction is likely to come in your leave-related policies when someone is diagnosed with COVID or is taking care of a family member diagnosed with COVID. First, if you have elected to continue coverage under the Families First Coronavirus Response Act, the FFCRA, then an employee diagnosed with COVID or taking care of a family member diagnosed with COVID may qualify for paid leave under the FFCRA, in which case you may be eligible for a payroll tax credit. Per the recent American Rescue Plan Act, the ARPA that Kathleen had mentioned before, employers have the option but are not required to afford employees FFCRA-related leave. It's an employer option on whether or not to offer FFCRA-related leave at this point. If an employer does grant FFCRA leave, the employer can seek reimbursement for wages paid to an employee on leave through a payroll tax credit up to the amounts identified in the law. And then one additional point from the ARPA legislation related to the FFCRA is that the leave taken to get the COVID vaccine, so if an employee goes out on leave to get the COVID vaccine or is out on leave to recover from the effects of the COVID vaccine, is now covered by the FFCRA. So if you're offering FFCRA leave to your employees and that employee goes out to get the COVID vaccine, they can, you can pay them for being out to get the COVID vaccine and then receive a payroll tax credit for doing so, as well as for the time to recover from the effects of the COVID vaccine. Next, an employee's COVID diagnosis or need to take care of a family member diagnosed with COVID may qualify the employee for leave under the Massachusetts Paid Family and Medical Leave Law, as well as the Family and Medical Leave Act if you are an FMLA covered employer. Whether or not either law applies will depend on whether the medical documentation for the COVID diagnosis results in the diagnosis being considered a serious health condition, which is a defined term in each law. One thing to remember is that employers are not responsible for determining whether an employee's condition qualifies as a serious health condition under the Massachusetts Paid Family Medical Leave Law. The employee is to apply to the Department of Family and Medical Leave, and the department then makes a determination as to whether or not to grant benefits. And this is unless, of course, you have a private plan, in which case the application process will depend on the plan terms. For those without a private plan, if an employee who is diagnosed with COVID asks them about PFML leave, you can direct them to the department website and application page so they can apply for PFML leave through the department. You should not discourage employees from applying for PFML benefits, even if you think it's unlikely even if you think it's unlikely that they're going to qualify. Let them apply and let the department make the determination. Then an employee also may earn sick time for time off related to an employee's own diagnosis with COVID, or to take care of a child, spouse, parent, or parent of a spouse who is suffering from COVID and requires home care or professional medical diagnosis or care. And then finally, if COVID-related leave is not otherwise covered by any of the previously discussed leave policies, or if the individual has run out of accrued or other leave, then if available, you may allow the employee to take leave under a company paid time off or vacation policy. Next slide, please. The other policy area I wanted to discuss relates to the Massachusetts Travel Advisory. So we no longer have a travel order in Massachusetts. We only have a travel advisory, which does not carry with it the force of law. Under the advisory, individuals who are not fully vaccinated are advised to quarantine for 10 days or obtain a negative PCR COVID test before ending the quarantine. When there was a travel order in place, we had a lot of questions from employers about putting in place a workplace policy concerning vacation travel. Employers may still consider enforcing such policies, as there are some places in the world and even in this country that are doing better than others with the vaccination and exposure rates. Such policies may include requiring employees to disclose if they are leaving Massachusetts for a vacation, requiring employees to get tested or quarantined before returning to work, or requesting proof that the employee is fully vaccinated before allowing the employee to return to work without quarantining or producing a negative test. This is another area where you'll want to consider your company culture when deciding whether to enforce any type of travel policy. And if you'd like to discuss your particular circumstances further, feel free to reach out to your go-to HRW team member or anybody on this panel, and we'd be happy to discuss it with you. And with that, I'm going to turn it back over to Kathleen to talk about some considerations for the remote workforce.
Thanks, Mark. So remote workforce, there's no denying that one of the biggest things that we've all experienced through the pandemic is the move to remote work for certain industries and how that continues to reshape the workplace in somewhat dramatic ways. One of the biggest ways that employers obviously dealt with the pandemic was to move their workforce in some instances to 100% remote, and some of you may still be 100% remote, depending on the business you are in. And some of you, on the other hand, in essential businesses have returned all or some of your employees to the workplace. But nonetheless, this workplace remote work issue is front of mind for many employers right now. Next slide. So we thought we would ask you, what does the future in this poll, what does the future hold for your remote workforce? So if you would please answer one of the 4 following questions. You'll continue now to operate, or you will operate 100% remote. You'll operate hybrid optional. All employees will be required to return to work, or you remain undecided about remote workforce. And of course, we recognize that for certain industries, this luxury may not exist, but for those of you in office environments, it's certainly a very large question right now about decisions. And we see that the majority of you intend to do some hybrid form of work from home. And next would be, that's 57%. 27% of you will require all employees to return to work. 14% of you remain undecided. And 1% right now will operate 100% remote. Great. Interesting data there. So next slide, please. So just a brief overview. We'll talk about return to work considerations, what you might think about with policies. Alicia will talk about compliance issues, and we'll touch for a moment on some best practices for you. Next slide, please. So there's no denying that many employees, some for the first time ever, got a taste of working from home during the pandemic. And many of them have recognized that they really like working from home, either all the time or part of the time, and the blend that might allow them the flexibility for their personal lives and business lives. One interesting data point that I've seen in the media surveys is that there seems to be somewhat of a disparity between what employers have noticed and what employees state about work from home. In some big companies where there's more vocal CEOs, there have been some discussions about work from home not being effective, not working. On the other hand, you've heard many employees, maybe some of yours, talk about how they feel like they worked in some instances even as effectively or as efficiently as they did while in the office, or even better because of the flexibility it provided them. So in any event, as you think through a policy, it's a really good idea to think about who will be eligible and what types of jobs will be eligible for remote work. And as part of that evaluation, it probably makes sense for you to look over your jobs and your employees over the last year and evaluate how that has worked or not worked, and what you can do to improve it, or whether it really requires that this position be 100% in the office. Things that might influence this include what the employer's job duties are, Perhaps you would like a tenure requirement going forward for which employees will be eligible to work from home. Certainly, you might think about whether employees who have performance issues that are on a performance improvement plan would not be eligible for remote work. As many of you already looked at this last year, you'll want to have some kind of conditions required for an employee who works from home in terms of remote Wi-Fi and data privacy concerns, and you might need to work with them to provide that information and those tools for them. Next slide. This is a very busy slide, but all this is saying is this is EEOC guidance that says just because an employer provided a remote work accommodation during the pandemic does not mean that that is in place in perpetuity. You can now reassess if you're reopening your workforce. You can engage in a new discussion. If an employee has a legally protected reason, you can have a new interactive process with them about a return to work. And if it's just part of a policy or a decision you're going to implement about work from home, you could have that flexible discussion with all of your employees. Next slide. And then additional considerations on the next slide include one of the things that Alicia is going to talk about is you can go back. Thanks. Is non-exempt employees working from home. And that was certainly something that happened during the pandemic that didn't really happen as much before that. And one of the areas to think about is reimbursement risks. In Massachusetts, and under the Fair Labor Standards Act, it's clear that an employee who is required to pay for expenses that are related to their job duties out of their pocket and that then takes their wages below minimum wage, that cannot happen. So it's important for you to look at that. The big question that a lot of employers dealt with throughout 20 and to current times is what expenses are reasonable. One thing to think about is whether you want to list what you deem reasonable expenses in your policy. For example, you may not think it's reasonable to pay for an employee's desk, nor may you think it's reasonable to pay for their Wi-Fi if they already have it, but it certainly may be reasonable to pay for the tools of their job, which include a computer. And there are some cases that talk about this in Massachusetts, but I think to the extent you can think through these questions, look back on the last year and come up with a list of what's reasonable, that might put you in a good position for moving forward. And with that, next slide, please. I'll turn this over to Alicia.
Thank you, Kathleen. And good morning, everyone. So it's safe to say that remote work is here to stay, at least to some extent. With this in mind, today I will cover some policies and touch upon some compliance issues that businesses should keep in mind while we navigate the waters of the remote workforce. Before jumping into policies and other documentation that mostly apply to remote workers, let's talk about policies in general. So in thinking about handbooks, for example, there are many policies that you'll want to specify that apply to your entire workforce. Let's take, for example, sexual harassment policies. Keeping in mind that sexual harassment issues are not immune from the virtual world, employers should clarify that their policies apply to both employees reporting to work on site and those working in a virtual environment. Additionally, often employers will include the contact information for federal and state enforcement agencies. So in thinking about this, employers should confirm that their policies specify the contact information for jurisdictions where they have any of their employees located, including the locations of their remote workers. In thinking about other policies that cover remote workers, let's touch upon telework policies. Kathleen mentioned a lot of considerations that employers may consider in thinking about their remote workers, such as eligibility and factors for determining eligibility, expectations as it relates to communication, having established work areas, etc. Telework policies are a great tool for employers to use to outline and specify what these sort of requirements and other procedures related thereto are for their remote workers. Additionally, the procedures for requesting to work remotely should be specified as well, along with the potential repercussions for violating any sort of telework policy that you have in place. Employers may also use telework agreements as an alternative option for telework policies. This would include the employer and employee entering into an agreement to establish what the arrangement would look like for remote work. Just like any other sort of employment agreement, you'll want to ensure that you specify that nothing contained in that agreement would alter the at-will employment relationship. Some employers may not have the need to enter into a telework agreement or develop or adopt telework policies, possibly due to the fact that they have a limited amount of employees working remotely. So to that extent, there are other options, of course, to document remote work arrangements, such as specifying in writing via email. However, employers should consider adopting formal policies or agreements to ensure that there is uniform and fair application to their entire workforce across the board. Speaking of other documentation, job descriptions are another area that relate to remote work. In reviewing job descriptions for existing or new positions, these are great tools for employers to use and take the time to specify whether a given position is eligible for remote work or whether a position will in fact operate 100% remotely. Likewise, job descriptions could also specify that although a position is eligible for remote work, that an employee may be required to periodically travel on site for trainings or meetings, for example. Likewise, in connection with measuring performance and productivity, employers should be sure to continue to do so for their entire workforce, for not only those on site, but those also working remotely. In the context of job descriptions that outline the various responsibilities associated with a given position, employers should periodically review these job descriptions, and in connection with evaluating performance, they should ensure that their employees are up to par with the expectations specified therein. Next slide, please. So before jumping into some of the compliance issues that we'll discuss today, let's consider a hypothetical. So a company is headquartered in Massachusetts with a few employees working remotely in California, Connecticut, and Texas. True or false? Only the laws of Massachusetts apply to the company's workforce. So if you could take some time and select either true or false, that would be great. Okay, so a remarkable amount of you selected the correct answer, which is false. Next slide, please. Next slide. Oh, thank you. So generally speaking, the jurisdiction or the laws of where an employee resides and works typically govern the employment relationship, including the terms and conditions related thereto. So it follows that compliance can be daunting for employers that have a multi-jurisdictional workforce. So today I'll cover some of these areas of the law that employers should remain aware of. And quite frankly, we could probably have a webinar dedicated fully to these topics. But for purposes of today, I just wanted to highlight some of these issues so that employers are aware as they continue to operate in a remote work setting, or at least a partial remote work setting. So first and foremost, many states and localities have specific leave laws and sick time laws that often provide greater protection to their employees located in their jurisdictions. It follows that these differences will often differ from where an employer's base is located, as well as federal counterparts. Differences can include anything from leave entitlements to reasons for leave, as well as leave administration. So a good takeaway in connection with leave laws and sick time is that in considering requests for leave, employers should familiarize themselves with these laws, especially before denying a leave request or terminating benefits. Likewise, employers should also review applicable leave law policies and sick time policies to ensure that they are providing any of their remote workers who may be subject to these laws with the requisite notice of their rights and policies and procedures as to how about going to request any sort of these types of leaves or sick time. Next, let's talk about wage and hour. So just like with leave laws and sick time laws, there are many wage and hour laws that differ state by state. In the context of non-exempt employees, employers should really be careful about or keep in mind that the meal and rest break requirements still apply, and that they should also ensure that non-exempt workers are in fact recording all time worked and being paid for all time worked. Being in the office or on site before the pandemic really provided visibility for employers to make sure that these things were happening. However, this visibility has somewhat been taken away given the transition from being on site to a remote work environment. So employers will just want to make sure that they're checking the box on these compliance issues. There are also wage payment laws that dictate, among other things, content for wage statements, permissible deductions, and timing for final paychecks. So while navigating through different jurisdictions where you have remote workers located, you'll just want to ensure that you're in compliance with all of these various wage and hour laws that may impact your business. There are also hiring considerations to keep in mind. There are state-by-state laws that govern background checks and when and what you can ask candidates, as well as restrictive covenants and prohibitions related thereto, as well as work authorizations to keep in mind. Next, there are also discrimination issues that vary jurisdiction by jurisdiction that involve differences around non-discrimination, harassment, and equal employment opportunity. For example, many states have state-specific requirements with respect to harassment training that vary on content, duration, and frequency. So employers should absolutely keep this in mind as well to ensure that they are complying and that their practices are in compliance therewith. Additionally, there are workplace notice obligations that state, federal, and local laws impose upon employers. Specifically, employers are required to post certain notices or provide notices to their employees regardless of their remote work status. So in thinking about this, employers will want to either electronically provide these certain notices or alternatively ensure that they're posted in a conspicuous location such as an employer's intranet. Finally, there are also workers' compensation, unemployment, and business registration and tax laws that may impact employers. So when having a remote worker work in a new state or jurisdiction, keep this in mind and just ensure that you're in compliance with these areas as well. That was a lot to cover in a little bit of a small amount of time, so definitely feel free to reach out with any questions. I will now turn the virtual podium back over to Kathleen. Thank you.
Thank you, Alicia. So to summarize a lot of the great content, and I agree this could be a webinar all by itself for you to take away today. Planning is key. It looks like most of you are thinking through this right now. And to the extent that you do have telework, drafting policies and procedures around that, and certainly a policy that isn't actually implemented isn't very helpful. So training your managers and your HR workforce around those policies. And as Alicia mentioned, the differences, if you're multi-jurisdictional, There are differences in terms of what number of employees you may have in a given state where certain laws trigger. There's equal pay laws, there's all the wage and hour laws that Alicia mentioned. So you'll want to consider that. One thing to think about is whether you want to have a handbook with appendices for different states, or whether perhaps you want to consider the state that provides the most benefits and give that to all your employees. So those are strategic considerations. The number of employees in a given state may trigger certain requirements over time. So definitely keep that in mind as you grow and expand. Document everything, remain informed, and as always, the best practice is to communicate with your employees and amongst each other in leadership. And with that, we have officially finished the content portion of our slides today, and it has been my pleasure with my colleagues to present this to you today. And I'd like to see if we have any outstanding questions. I know that Dave and Kathy and Mark have been answering some questions in the chat box. Are there any questions outstanding? You can either insert in the chat box now, or Mark might have noticed some patterns here.
Yeah. So I'm gonna identify a couple, and like Kathleen said, thank you so much to Dave and Kathy for jumping in and answering those questions. I've been monitoring the chat box myself, and I think all the questions have really been answered. But one of the questions, Kathleen, you may be able to talk about this a little bit. Can you talk through some of the one of the questions is about reasonable accommodation requests for telework and denying a request based on an undue hardship. You talk about some of the things you look at, some of the things you think about when you get that request, especially after this time where people have been remote working for so long. You get the request for telework. How do you address that or handle that reasonable accommodation request?
Right. And, the challenge here, of course, is that the employee will cite evidence of their successfully having worked at home over the course of the past 15, 16 months as proof that they can that they can work from home effectively and efficiently. So one of the key points for you to think about as an employer is whether that is in fact true. And hopefully, if it isn't true, you've got some documentation over the course of the last 16 months as to how it isn't true, that certain collaboration hasn't happened that needed to happen, that this employee didn't meet certain expectations. So that's part of the dialogue about whether this employee in particular and this job in particular really lends itself to a work from home. And that interactive dialogue and that discussion about the undue burden, I wish I could give you a bright line rule around this, but it really does come down to the circumstances surrounding that job, your business, that employee's work and productivity. But certainly there are factors that you can consider. Financial burden is one of them, but it's certainly not a big company really shouldn't hang its flag on the fact that it would break the bank for an employee to work at home as a financial hardship. There may be jobs like a teacher or a nurse or a doctor that it just cannot be done without in-person work. So what you'll want to do is look at the essential functions of the job. That's really what this analysis comes down to. You're not required to accommodate away the essential functions of a job. So if an essential function of a job is to perform in-person medical examinations, that could be grounds for an undue hardship where you would not grant that accommodation to the employee. So it's gray, it's always going to differ, and even in the same job with two different employees, the analysis may differ.
Yep. Thank you, Kathleen. And I want to be cognizant of everybody's time. It's where we just hit the 9:30 mark. We're going to stay on for a couple more minutes, but to all the attendees, just want to say that we really appreciate you coming and working with us and bearing with us on the postponement. If you need to get out of here, completely understand. If you want to hang on we're going to hang on for a couple minutes and just answer some of the questions that may be left. So one question that just came in and had come in before is, how are we handling masks with respect to visitors to the office and making employees feel safe? And I also saw this kind of question in the context of if we're requiring unvaccinated employees to wear masks, should we be requiring vendors and guests for proof of vaccination or to wear masks when they come in? And Kathy answered this question in the chat. I think it was spot on. You know, it's really going to be a business decision. It's going to be one of those, you love to hear from a lawyer. It depends, right? It depends on your circumstances. It's going to depend on your customers, your employees. At the end of the day, you know, you're really just going to have to make the decision for what's right for your workforce. There's not really, you know, a cut and dry legal answer, right? You know, it's not as if you're requiring it for employees, you have to require it for guests. That's not the case. You can make the distinction. It's really up to you. But, you know, you should keep in mind that if you're going to require for employees and not require masks for guests, the employees may get a little upset about that, and they may question that decision. Vice versa, you know, if you're going to require for guests, but the employees don't have to wear it, you know, some of your guests may be a little thrown off by that and wonder what the situation is. And just like the myriad of options that there are, if you require it for nobody, there's going to be some people who are upset that people aren't wearing masks. And if you require it for everybody, there's going to be people who are upset that they have to wear a mask. So you're really going to have to look at your circumstances and see what works for you, your business, your industry, and your customers. Especially as things start to reopen and we're trying to attract those customers back into the workplace. You know, and we will, I think we can stay on for one or two more questions. I saw a few questions in the chat about OSHA recording requirements and OSHA guidance. I'm going to drop in to the chat right now some updated guidance from OSHA that was effective as of March 12th. And I'm going to refer people to that guidance if they have OSHA specific questions, as well as the general work. There was a question about whether or not if an employee had been diagnosed with COVID a few days since their last shift, whether or not that was a recordable event. And that's going to, you know, depend on, you know, determination of whether or not the COVID diagnosis was work related. And it's not, the OSHA regulations, which I'm going to drop into the chat right now for that. It's 29 CFR 1904.5. Doesn't have a cutoff on the timing of when, you know, something becomes or is no longer work related after a certain amount of days. It's really going to be an analysis that you have to do with respect to the employee's condition. You know, like John mentioned, we would expect some guidance potentially from OSHA soon, as they're reevaluating their current guidance based off of the CDC advisory. So, you know, keep an eye out for that. I'm sure once any updated guidance comes out, if it's something substantial, you'll be seeing a client alert from us. So, you know, keep an eye out for that as well. And I'm not seeing any other questions coming in immediately with, you know, the time running out right now. I'm going to say that, you know, I think that's all set, and we'll follow up with an email, or anybody can follow up with an email, reach out to any of the panel members or your HRW go-to contact with any questions that you may have. Thank you all again for coming. We really appreciate your attendance, and good luck as things start to reopen.